Order. Just stand for prayer. Dear Heavenly Father, thank you for waking us up to see a brand new day and giving us health, strength, and a sound mind. Thank you for the bless this board. Lord, I ask you to give us the knowledge to make the best decision for the county. And thank you in all these blessings. In Jesus' name, amen. Amen. Stand. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Number 4, notice of increase in tax assessment and real estate property. Emmanuel Robinson Gregory, 6824 Jackson County Line Road, Mossburg, Mississippi, 39562. PIND 000804445-00 as published in the Sun Herald. Is Mr. Emmanuel anyone here?
Mr. Morris, I need to remove that one due to a publication error with the Sun Herald.
Okay. Thank you. Okay, B, a call in Sean Dunaway, 100 Johnson Street, Ocean Springs, Mississippi, 39564, PIND D 61060046-00. Anyone here from Ms. Dunaway? Can I get a motion in a second? Mr. Taylor?
I'll second.
Second, Mr. Combs. All in favor by saying aye?
Aye.
All opposed? Ayes have it. Thank you. See, David R. Estabrook, 804 Grant Avenue, Pascagoula, Mississippi, 39567, PINDN 40406022-02E. Anyone here for Mr. Estabrook? For it? Can I get a motion in a second?
So moved. Second.
Mr. Ross and Mr. Bozar, second. All in favor by aye?
Aye.
Any opposed? Ayes have it. The Lauren Timmons, Section 26 Township, 7 Range, 8E half, Southwest, 1/4 of Northwest, 1/4, PIND 60126-140-025. Anyone here for Mr. Timmons? Can I get a motion in a second?
So moved.
Motion by Mr. Combs, second by Mr. Taylor. All in favor by saying aye?
Aye.
All opposed? Ayes have it. Gerald E. W. and Marilyn M. Blackburn, 3906 River Pine Drive, Mossburg, Mississippi, PIDN 22000080-000. Anyone here for Mr. Blackburn, Mr. Gerald? Can I get a motion in a second?
So moved.
Mr. Thomas, second by Mr. Taylor. All in favor by saying aye? All opposed? Ayes have it. Number 5. Amendment to the agenda. Do I have any amendments, Mr. Combs?
I don't have anything.
I don't have anything, Mr. Moore. Mr. Taylor?
No, sir.
Mr. Ross?
No.
Mr. Bozart?
No.
Josh is not here, Josh. Brian Porter?
No, sir.
Joe Neal? None. Jimmy Carmer?
I have one, Mr. Morris, under consent. The very last item is Port of Pascagoula. There are 4 items under the port, under consent. Port Director Alan Muller's here. This was one, I guess, that we just didn't see. They had approved a budgeted item for a new vehicle to be used for the terminals for maintenance personnel. The price of the vehicle is $57,478. They had budgeted $65,000. I would suggest that the agenda be amended under consent under Port of Pascagoula. Mr. Moeller's here if anybody has any questions, but if nobody has any questions, I'd like that amendment to be placed
Okay.
under consent, Port of Pascagoula.
Okay. Any other?
Mr. Morris. Under my own, on consent, under the form 71-026, the form for American Tower Corporation needs to be pulled, please.
Say that again, I didn't hear you.
The form for American Tower Corporation needs to be pulled under my items under consent. Stephanie has it.
Can I get a motion on the amendment agenda?
So moved.
Mr. Bozard? Second, Mr. Ross? All in favor by saying aye?
Aye.
All opposed? Ayes have it. Public comments. Anyone here for public comments?
Hey, good morning, everybody. Matthew Hosey. I just wanted to make a quick announcement because we're having our final public meeting for the Jackson County Resiliency Plan that we've been working on. That public meeting is going to be on March the 2nd in the afternoon from 5 to 7 p.m. at the Fontainebleau Community Center on Highway 57. And so we've just been wrapping up this plan. We're really just gonna have like a presentation available, show the public, you know, how the plan is shaped up to be, and then have a discussion and a Q&A session in case anybody wants to ask any questions. So we're gonna be putting a copy of this flyer up on Facebook, our Facebook page later this morning. And Neil Schaefer is also gonna be helping promote the public meeting as well.
Thank you, Matthew. Thank you.
Anyone else, public comment? Thank you. Number 7, can I get number 7, consent of the agenda, can I get a motion in a second? Mr. Taylor,
I'll second.
second, Mr. Thomas, all in favor by saying aye?
Aye.
All opposed? Ayes have it. Number 8, department heads. Finance, Ms. Wells.
Good morning. The first item I have is to order approving the claims docket.
Can I get a motion?
So moved.
Motion by Mr. Combs,
Second.
second by Mr. Taylor. Any questions? All in favor by saying aye? All opposed? Ayes have it.
Okay, and the last item is the resolution authorizing the interfund loans for fiscal year September 30th, 2026.
Can I get a motion?
So moved.
Mr. Bozard? Second by Mr. Ross. All in favor by saying aye? All opposed? Ayes has it.
Thank you.
Inventory, Ms. Barnett?
Good morning.
Good morning.
I have 2 resolutions. The first one is a resolution authorizing the removal of computer monitors from inventory.
Okay.
This is just for tracking purposes.
Can I get a motion?
I move.
Ms. Taylor?
I'll second.
Second by Mr. Thomas. All in favor by saying aye?
Aye.
All opposed? Ayes has it.
And the second one is a resolution authorizing an intergovernmental sale of a fire brush truck to the Gulf Park Estates Fire Department.
Can I get we got the motion by Mr. Bozard?
Yep.
Second by Mr. Ross. All in favor by saying aye?
Aye.
All opposed? Ayes has it.
Thank you.
Thank you, Ms. Barnett. Mr. Edwards?
Morning, everybody.
Morning.
First thing that's under me is the resolution adopting and making part of the public record Acadian Ambulance Services, customary and usual rates. And Derek McCoy here with Acadian can speak to that.
Yeah, I believe I had our legal department speak with you, Mr. Comer, and hopefully explain some of it. But basically, we're asking for a resolution to place our rates on the public record. And the reason why we're doing that, I'm not gonna go in too deep, but there was a bill that was passed and signed into law a couple years ago. And basically it says the minimum allowable reimbursement rate under any policy to an out-of-network ambulance service shall be rates contracted between an EMS provider and the county. In the absence of rates, minimum allowable to an out-of-network provider shall be the greater of 325% allowed by Medicare or the provider's bill charges. So there's some counties, well, there's a lot of counties throughout the state that doesn't have rates set, you know, in their contract or granted by their government authority. So we have rates, but what's happening is, as some of you know, we've had citizens in this county that I've had to work with, particularly in the last year, that has, you know, a particular insurance provider that is not covering what this law states they shall cover, you know. And even if we were out of network with the provider, which we are, because they will not come to the table and get a contract with us. And I don't believe they have a contract with any ambulance provider in the state. So therefore, they shall be paying, according to this law, what the rate is that is adopted by, you know, you. So that's why we're asking for y'all to do that. And that way it kind of shores that up, and then we can go back to them and try to force them into paying what they should be paying instead of putting it on the backs of our citizens, which is kind of what they've been doing. So I'll give you just a quick example. You know, I've got one explanation of benefit here, and this is just one example. You know, if you go by this law, let's say they were out of network, you know, and we didn't have rates. Well, according to the law, the insurance shall pay, you know, they shall cover about $1,400. Well, in this particular case, they only paid about $400. You know, so that's a huge deal. So that's why we're just trying to come back, get this done here before y'all and get it on the record so we can get that done and go back to them and try to get them to, you know, answer them bills correctly.
And really what happens if the insurance providers don't cover the rates or don't cover the cost of what it costs for the ambulance service, then eventually we get into a situation where we're having to provide a subsidy to the ambulance service, and that would be across the state to cover what these charges would be above and beyond, you know, what they're reimbursing. And so, and I think we need to approve this. I think I would recommend that you do approve it. But there is a bigger problem that's still kind of looming in the legislature right now. There's a House Bill 1657 that's passed that would set those rates much lower than 325% of Medicaid. And so that's still being discussed in the legislature right now. But in the short term and maybe for the long term, we need to go ahead and adopt these rates and kind of protect, you know, the contract that we have now. So.
I'm gonna make the motion, but with a question. So how are we gonna get these rates out to the public on our website, or how are we gonna make it available for the public to see them without having to do a public records request?
So the current bill that's on the floor, and it's something that we've pushed. It was something we pushed when this bill was passed 2 years ago. We're pushing, and it's in the current bill that's on the floor. There's some good things in there, and one of those things is there shall be a database that is administered by the insurance department, state insurance department, and they'll be able to go on there and see all of the providers' rates. That's what we're pushing for. So
In the insurance department, a state insurance commissioner is gonna do this?
well,
Talk to him?
If the bill passes.
if the bill passes,
Yeah.
Do it.
yeah.
In the interim, the short term, it's going to be as part of our minutes. You know, it'll be available online. You know, we could take it a step farther if we needed to, but it's definitely part of the minutes of the board of supervisors.
I just don't feel like this warrants somebody having to pay for a public records request to get a rate, you know, so we need to make it available to the public free of charge somehow or another.
They can contact me and I'll give them the rates, or we'll talk about that on our side and see if we can't do something to.
Okay.
But I mean, in the meantime, they can call me and I'll provide the rates. That's no issue.
Okay.
Or somebody call my office, Mr. Bossard, wouldn't make them go through the hassle of a form and
Yeah.
prepayment of
That's all
costs.
we need. We just need to make sure.
We
there's
just
no-
send them the rates. And as I understand, these are statewide rates, correct?
So, yeah, well, what they're trying to do is lower it from 325 to 200, but here, these
I mean,
rates.
These rates.
These rates are set by each government body, you know,
The Jackson County.
yeah. And they did
Really, the
that.
difference in this is if we don't set the rate stays the same, but the burden of the payment falls on the taxpayer instead of the insurance company. So, I mean, really, it's one of those cases where counties have an option to either subsidize the rate, allow the taxpayer to foot the bill, or to hold the insurance company accountable for paying their client's bill.
And that's what we're trying to do, you know, we're trying to hold them accountable to what the law says. This is just kind of shoring that up for us, so when we do go before them.
Okay. I'll second that motion.
Okay, Mr. Bossart, second by Mr. Commerce. All in favor by saying aye?
Aye.
All opposed? Ayes has it. So it
All
passes.
right, thank y'all.
Thank you.
Okay, girl. Discussion.
Okay, the second item I had was out of that $140,000 that was recovered and placed back into my budget, I wanted to spend approximately $60,000 of it to buy 3 brush skid units for firefighting. We've got 3 odor skid units. And what a skid unit is basically a self-contained unit. It's a water tank, a small pump, and a fire hose that we use to fight brush fires with. We have 3 right now that the volunteers bought back in the 80s, and I wanted to replace those 3 using part of that fund, and that's what I'm asking to do.
Skid mount, you pull them up in the back of a
They go on the
truck,
back of the pick, it's one
big unit.
big unit, it just slides in there and you bolt it down to the bed of the truck.
Oh, okay.
They call them skid units, I guess because they skid out if you don't lock them down. I don't know why they call them skid units, but that's what they are, what they're called.
You already have the trucks you're gonna put them on?
Yeah.
Okay.
Yeah, we're gonna take existing trucks, pull these older units out and put the new ones in. And then the older units belong to the volunteers, and they're gonna give 2 to Gulf Park and 1 to George County.
All right. I'll make that motion.
Let me ask Brian. Brian, do we need a budget amendment?
I don't know. I don't have his budget in front of me right now. So do you have money in your budget for this?
I don't know,
I mean,
we gave finance the $140,000 check, I don't know, and they got with Josh, and I'm not sure where the money went to.
Okay.
How they put it back in my budget.
I'm pretty sure
So-
they did.
So Jimmy, do we need to do a motion on it? Or
I think we need a motion on what he's requesting. I was just wondering, I know the 140,000 came in by check, and I wondered if it got to your budget, because you're requesting to spend some of that, and I was just asking Brian the details of if that.
I know there are a lot of capital items that were budgeted in fire, and so I don't know that you've spent all your capital
I don't
funds
think
so
we spent all
far
the
this year.
capital, but Josh was gonna figure out where to put that 140.
Right, I mean, I guess we could always do it next meeting if Josh thinks
Yeah,
it's
because we won't,
necessary.
it's gonna take 10 weeks to have them built, so.
Okay, yeah, all right. I'll remember to ask Josh to check on that, make sure that's done.
Thank you.
I made the motion.
I'll second it. Go ahead.
Motion by Mr. Bossart, second by Mr. Commerce. All in favor by saying aye?
Aye.
All opposed? Ayes has it.
Y'all have a good day.
Thank you.
Okay, waste, solid waste, Ms. Rhonda. Ms. Rhonda.
Dennis is here.
Good morning.
Good morning, Dennis.
This item is an approval for for an MOU with America's Thrift Store to place some collection containers just inside the gate at the Seaman Road landfill. I don't know, did y'all have a list of is that part of your package?
I didn't see it.
I
That's what
didn't
I
have
was
it.
gonna ask you. What is this
Yeah,
gonna?
I brought some. I looked at
Okay.
your package and I didn't see a list in there. It gave us a list of things to take.
Textile.
They're wanting to bring them to our landfill?
Just a couple of containers, just like you see around town and shopping centers. and
Oh,
stuff.
okay,
I think there
okay.
was some pictures in your package.
So basically, instead of this stuff going into the landfill, it can go in one of those boxes.
Exactly.
Okay.
And that's one of the benefits. Anything we can keep out of the landfill, extends our capacity that we have. Another thing is several of the items that they collect, clothing, cookware, they have some substances in them. They're called forever chemicals. EPA is writing some regulations now. They haven't come down with limits that, we'll have to meet, but it's coming down. So this is kind of proactive on our part to try to keep this stuff out of the landfill. And another benefit is they're a charity partner with Home of Grace. So we think it's a good program and we're looking forward to it.
If I can make one comment, because I had a long conversation with Rhonda about this, because I didn't understand it first, but my understanding is people will bring these items to the landfill with the intent to throw them away. Of course, I asked Rhonda, why don't you just put them in a garbage can and or put them by the side of the street? But apparently people bring these items that are usable to the landfill with the intent to throw them away. This resolution will allow American Thrift Store to set up these collection boxes so that those items which are usable, which before would go to the landfill, will now be collected and I guess cleaned or whatever that you need to do with it, and then sold, and will not go into the landfill. So I guess I just never understood that. I had to ask Ron to explain it a couple of times, but it sounded like a really good win-win for everybody.
It's kind of what I thought it was when I saw it,
And we won't have any labor involved. It'll be by the gate attendant. They'll be able to see in case they get full, let us know. We'll call them, they'll come get them and keep people from leaving stuff on the ground outside, around the boxes. We don't want that. But they've told us that, whatever frequency we need them to come, they will come. And if we need more boxes, they'll bring more boxes. So we think it's a good program.
No cost.
No cost to the county.
The only thing that concerns me, and the landfill's in my district, so the only thing that concerns me is, on the weekends or whatever, they don't need to pile that stuff outside the gate. If they can't get in, they need to come in during regular times, but I just see that being an issue of people just dropping stuff off outside the gate.
Well, we'll definitely keep our eyes open, and if that becomes a problem, then we'll have to figure out another way to do it.
Because those ones at the park and ride, that's all.
Well, I was gonna ask about that, if we could
Get
touch
rid of
base
those.
with the ones at the park and ride, because when I still was drilling for the National Guard, I was in that park and ride at 3 in the morning a couple of times Saturday morning, and I watched people pulling stuff out of them and slinging it around. I guess they were sorting through what they wanted and pulling it out, throwing it all over, and that's what led to some of the litter problems in that park and ride. And while I was there, I called the sheriff's department, and they actually came and made them put it back in. But for all the time someone's not sitting there calling, that stuff just gets thrown all over. So it'd be nice if we could get them to keep a better eye on those, or clean up after it, or maybe move them and put them all in that one spot.
Okay.
I believe in the cause. I believe in it. I think it's great, but I just want to make sure it doesn't get out of hand with piles of debris.
Right, and there's language in the MOU that if it's not working out, I think it's 15 days or something like that, we could say, look, we tried, you're gonna have to come get them.
Anything we can keep from going in our landfill like this, I'm good with it. I just want to make sure it doesn't get out of hand.
Yeah, and
Appearance-wise,
we have minimum recycle goals that we recycle a lot of stuff at the landfill, and this is something along those lines where these substances that EPA is gonna regulate or is in the process of regulating, we're keeping them out.
Good.
So we're being proactive here, and hopefully we get some credit from the state for doing that for the program.
Yeah, good. Thank you.
Dennis, I agree with Mr. Ross said. I would like to see if there's a way to move them to the landfill, do away with the one at the parking lot.
Okay.
We'll
let them know.
We've been working on that.
Josh Martin on that, and Josh said he works with them, and they're gonna move this from the parking lot. I think this is what they're gonna do instead.
Okay.
I'll make that motion.
Mr. Bozarch. Second by Mr. Ross. All in favor by saying aye.
Aye.
All opposed? Ayes has it. Thank you, Dennis.
Thank you.
But we could wait till 10 o'clock for planning. We'll just move to action items. Mr. Fulton?
And I got kind of a long list today to go over. For the state delegation, I guess everybody knows they're probably about halfway through with the session. So a lot of bills have been introduced in one chamber or the other, have made their way out of the chamber or they've died and into the next chamber. So I'm going to kind of go through some of the ones that I think are more relevant to the county. And if you have any questions, we can talk about it. First was the Senate Bill 2432, which is the municipal inmates bill that we have been discussing for a while. It passed out of the Senate 52-0. That's the one that allows us to negotiate with the cities on the rates for holding the inmates in our jail. So that's looking good so far. House Bill 1525 and also House Bill 1314 are group purchasing bills that would allow the county to have some more flexibility on group purchasing instead of only being able to go off state contract. Also in 1314, it raises some of the thresholds for POs, competitive quotes, and public bids. It actually raises public bids from $75,000 up to $100,000. And also makes reverse auctioning discretionary, which is something that we've been having issues with throughout the years. House Bill 1383 is kind of an interesting one. It deals with ad valorem tax notices, which would require all taxing authorities, including the county, to send out an annual notice to all property owners disclosing what their taxes were for the current fiscal year and what their taxes would be at the next year if the millage rates did not change. And so really it basically tells them what their change in value is and if they could be anticipating a tax increase or decrease based on the values for the upcoming year. So that's an interesting one.
Yeah, it is, Brian.
House Bill 1652 deals with the clawback of funds that were in the 2021 CapEx bill. The county had 2 projects in that bill, and we are in good shape, right, Sonia? We're in good shape on those 2 projects, so we don't have to worry about money being clawed back. There were some city projects out there, and we notified the cities of the ones that they had in that bill, and I think there was only 1 project that was in jeopardy of getting funds clawed back. Since that one went to the floor, they added a amendment to the bill, which added a reverse repealer in it, which means that it would likely go all the way to the conference stage of the legislative session. And I think there's at least one of the cities that hopes there'd be some language included in the bill that would give them some more options instead of just taking back the funds. Senate Bill 2409 is a retrofitting bill, which would allow grants of up to $15,000 for people to retrofit their houses. I think this is a push to go towards fortified standard roofing, and that would be good for Jackson County. House Bill 683 is the purse seine fishing bill, which pushes fishing 1 mile offshore using purse seine nets. House Bill 2004, which is the PERS funding bill. As you know, there was about $600,000 in that going towards PERS for the retirement fund. It's passed the Senate. Senate Bill 2264, which is the Mike Thompson's bill that he passes every year out of the Senate that creates a coastal master plan, if you will, and it would require a board that would produce a coastal master plan for funding resources. So any funds that came out of the Restore Act or BP funds or Tidelands would have to be to fit within the narrative that's created out of this master plan. That's not been a very popular one on the House side, so we'll see how it does over there. Senate Bill 2480 transfers $265 million to MDOT for capacity projects. Senate Bill 2826 raises the homestead exemption from $7,500 to $20,000 of assessed value, which that's the amount that people are exempted off homestead exemption, which impacts the county. It impacts every county. We've ran some numbers on that. We think it could have a negative effect on the county by the tune of about $300,000 to $400,000 every year in taxes. The big one that we're kind of watching, and there's a version in the House and in the Senate, is the ARPA clawback bill, and it affects the projects that we have in our MCWI program. When we got the ARPA funds, we developed 19 different projects. 3 of those were strictly county projects, and then the other 16 projects, we partnered with the cities and the utility companies to help them fund water and sewer improvements. And those went through this MCWI program that the state set up. And so the legislature, those funds are supposed to be spent by the end of this calendar year. But as a safeguard, the legislature is considering putting a new date in there and saying that the funds need to be spent by September 30th. Because any unused funds at the end of the calendar year would go back to the federal government, and they don't want to do that. And so they want to claw back the funds on September 30th and be able to put those into an MDOT paving fund, which is also eligible for ARPA money, and pave enough roads between September 30th and the end of the year to spend the remainder of funds. Well, that sounds good, and that can be a good plan, but if we've got active construction projects going on that don't finish up on September 30th, then it kind of puts us in a pinch. What do you do? What do you do if you've got an open contract and the state takes the funds away during the middle of the contract? And so that's a big problem for us. And so we've been going through a process with Matthew and Sonia, helping to try to figure out, which projects we have that may be in jeopardy of falling in that trap. And we've identified at least 7 projects now that have spent less than 50% of the funds allocated towards them, and so those are kind of in the red zone, if you will. And then out of those, we really only think there's a couple of projects that may not finish by the end of the year. And so we're trying to get up-to-date numbers. We're trying to communicate with the cities and utility companies on these projects and have the best and most accurate data that we can have, so that when we go back and talk to the legislature about it, that we can better explain what our situation is and maybe get some compromise language added to the bill that would allow us to finish the projects without having the money clawed back. And so that's kind of a big deal that we're trying to work through. So more information on that one to come. I'll keep you guys updated on it.
Is MDOT working on a plan to, say, pave roads with this money that's clawed back and free up other state money, so that if the project does continue, there's a way to maybe give it back out of state funds instead of having the federal funds that are going to get pulled back to the federal level?
That's not in the bill, and that may be.
If they put something like that in there, then you'd have a contingency fund if a project's still going on, that they'd be freeing money up to move back if it's completed.
And that's a good idea, but currently that language is not in there. That would be something that we'd have to talk to them about. So anyway, I'll keep you all updated on that one, but that one's kind of got us worried a little bit. So some of the dates, there's some deadlines coming up just to kind of give you a sense of where they are in the process. Now they're going to kind of turn towards appropriations and revenue bills, and so the next deadline to submit language for a bill is the 23rd of this month. So I'm going to be up there this week talking about our funding request as they get ready to start putting together appropriations and revenue bills with the deadline of the 23rd. Also, the next deadline for general bills to come out of committee is the 3rd of March. And so all the bills that kind of went over to the other side will have been assigned to a committee, and then they'll have till the 3rd of March to come out of that committee before they get to floor action. And then lastly was the deadline for local and private bills to be submitted is is the 27th of March. So we've still got plenty of time on the local and private stuff. And that's kind of what I had for the state side. I had a couple quick ones on the federal side, unless there are any questions. Federal side, just the THUD grant applications are coming due, and we were looking at reapplying for bridge funds for the Tanner Williams Bridge. That's one that I've been working with Joe on, and so we want to submit the same application that we did last year on that. We think there may be a good chance, since it was reviewed last year, to maybe get some funding this year, particularly on the Senate side with Wicker and Hyde Smith. On the House side, wanted to talk about possibly submitting a grant application for the sheriff's office and seeing if Ezel may be able to help us with that. And so I'll be reaching out to the sheriff on that, and if he's interested in that, I'll bring that back to you guys.
Sounds good.
Any more questions?
Thank you.
Thank you. Supervisors items. District 1, Mr. Commerce,
I didn't have any.
Anything, District 2, Mr. Taylor?
I have a comment. We're about to go into closed session and executive session. I would ask maybe today that we consider meeting in the executive conference room, because we got 40-ish people here that we're gonna make get up and get out.
Yeah, I thought about the same thing.
So
Yeah, okay.
that's what I would suggest we do.
For sure, okay. Mr. Ross, you have anything?
I don't.
Mr. Bozarch?
Nothing. Auditors are not in there, huh?
I don't think so.
No?
Okay, good.
Mr. Carmen, do we need to,
Yes,
wait
sir.
till planning?
Mr. Morris, we have 3 items for potential executive session. The first is the negotiation and acquisition of some property by the road department. I wanted to discuss that and provide some legal advice on that matter. The next is a personnel issue that I want to discuss with the board. And then the third thing is a discussion with regard to Pascagoula annexation litigation that's ongoing.
Can I get a motion to go in closed session, and we'll be back at 10 for planning?
So moved. Or I'll second.
Second by Mr. Taylor. All in favor, by aye? All opposed? Ayes has it. Thank you. We'll be back at 10.
Session, there was action taken by the Board of Supervisors. The board approved a resolution of the Board of Supervisors of Jackson County, Mississippi, authorizing an administrative adjustment to the appraised fair market value for acquisition of right-of-way needed for the Highway 609 and Old Fort Bayou Road project, parcel number 06110501.000, owned by Quang Van Tran. And the board unanimously approved this resolution, offering to pay for the acquisition of this property the sum of $35,000. Other than that, there was no additional action taken in executive session.
Are we ready? Mm-hmm. Okay, December 17th, our last planning commission meeting, we heard the application for a use permit. This is USEP-2025-00159, and this would be a request to authorize the operation of a Class 1 rubbish facility. The proposed facility would accept construction debris, brick, mortar, concrete, leaves such as that, of course, natural vegetation, and other waste approved by DEQ. The applicant of the property is Hensey Enterprises, Eric Hensey. The property is zoned A1, General Agriculture. It encompasses approximately 189.35 acres. Of course, it's currently being used as a dirt pit and a Class 2 rubbish facility. It also has some shop and office areas on the property also. Jimmy Lane represented Hensey Enterprises and submitted materials outlining the need for the proposed facility. Following the discussion, the Planning Commission voted 4-2 to approve the use permit. Several members of the public attended and expressed concerns related to road access, dust, drainage, those type of things. And an appeal was filed by David and Sarah Smith, and I believe they're here today to present their appeal.
Thank you.
Do you have a copy for Mr. Ketchum? Yeah, mine just needs to have, he needs to have a copy for the record, please.
Do y'all need the computer?
Marcus? Make that part of the record, please.
Yes, sir, thank you. My name is David Schmidt, 17113 Indian Lane, Vancleave, Mississippi, 39565. First of all, thank you all for hearing our appeal. I just want to be clear that I'm a representative for a large group of residents along those two drives, and some of that is substantiated through the signatures that you see in the package. There's 3 documents in the package. The first 2 are signature sheets that are almost 40 signatures from the local residents in the area along the access roads. And the last one is a copy of the filed appeal. I would just like to summarize our filed appeal to the Jackson County Planning Commission's approval of the permit application for the proposed Hensey Enterprises Class 1 landfill. That Class 1 landfill would be the same designation as the landfill we have on Seaman Road, so similar type materials in that class. As concerned residents residing on the access roads of this proposed facility, we believe this approval failed to adequately address the Commission's own stated criteria for evaluation. whether the proposal is in harmony with the neighborhood, and whether there is a demonstrated need for the facility. Their decision overlooks the significant community opposition, as evidenced by the signatures that you see here, the environmental concerns that were raised, and the existing 5 Class 1 landfills in Jackson County and many other Class 2 landfills that would be better candidates for the Class 1 landfill did not have the same potential for harm in our local community. I want to address that second point first. The fundamental need for this facility was not adequately demonstrated, especially in light of the many other available facilities discussed at the hearing. These facilities have capacity and are not surrounded by residential areas, or are they adjacent to natural features such as Cowpen Creek. A new landfill here would unnecessarily duplicate services and impose undue burdens on the community and the surrounding environment. Also, the proposed site is not compatible with the surrounding neighborhood, as proven by the strong opposition expressed during the planning process. Residents currently have issues with the facility as it exists now, with littering, speeding vehicles of all sizes. See this proposed facility decreasing property values, increasing traffic, and several environmental concerns as well. The site is adjacent to Cowpen Creek and therefore raises concerns about contamination to not only the creek itself, the surface water, but also to the well waters, the wells that we all depend upon in the area. Adding to these concerns is that less than half a mile from the new Prospect Methodist campground that was established in 1880. This site has been part of the community in Jackson County for over 140 years, and placing a landfill on its adjacent Cowpen Creek would threaten its historical integrity for the same environmental concerns. I'd like to close with this summary. The Planning Commission stated that their criteria for approval was twofold: harmony with the neighborhood and a need for the facility. The approval did not adequately address either one of these 2 points to support the approval. We gave them input emphasizing the lack of harmony with the neighborhood, and there's no substantial support except for the opinion of the applicant offered for the need for the additional landfill. The only remarks reflecting consideration of those criteria by the Planning Commission were that it was a difficult decision and speculation that the proposal might not even get passed by the Board of Supervisors. This approval undermined the whole review process and doesn't fulfill the Commission's responsibility to ensure the quality of life for residents, long-term sustainable planning, environmental protection, and community compatibility. We implore the Board of Supervisors to uphold our appeal and deny this request due to the applicant not meeting the stated criteria to merit approval. Thank you.
Yeah, it's against anybody for it.
Anybody else want to speak
For it?
besides him? You want to speak? Come on, let's give your name and address, and then we can bring the applicant up.
Good morning. My name is Lisa Price. I live on 18914 Highway 57 Ridge, otherwise known as Appaloosa Ridge, the direct route for many, many trucks in recent years. I can only say that when Lee Bond was trying to market this property and owned only part of the road, I am partial owner of the Appaloosa Ridge Road. There are 2 other people on this street that own part of that road. There are issues there that have not been discussed. There is certainly, going back to the previous speaker's point on preserving certain natures, this is a residential area. Mr. Lane's information was old, outdated. There's more than 3 or 4 homes. It is developing. Property is being sold for more. Half a mile south, and certainly north of Campground Road and Indian Lane, there is an area that I believe Mr. Holden sold that has now been cleared for over a year, and is going to have multiple homes built by D.R. Horton. This is directly on Highway 57 and the corner of Wade Van Cleve Road. This is going to have huge implications with a garbage dump street just half a mile, about a mile, closer to a mile, just to the left. Traffic and all these other kinds of considerations we've already talked about. Also, water quality and the draw on water. And when it's not maintained because things like old abandoned cars or wrecked cars, whether they've been cleaned of their gasoline and oil or not, have been brought into this dirt pit for years. I've physically seen them years ago. And that's what was going then. You know, they've been taking a lot more than just construction debris. And if this is the people that you all trust, there are implications here. I know we have EPA steps and things to go through, but you had a nice residential area up there being developed, and as storms come through and there's a migration off the coast to these areas, they have to be preserved. A bunch of dirt pits and a county dump is not the way to do it. And we are directly off 57. We have $400,000, $500,000 homes. We have 20 or 30 people on Appaloosa Ridge. I mean, between the children and the adults. You have a lot of children there. This is a nightmare waiting to happen. And you've got people that are vigilant and aren't going to just be run over by dirt trucks. So please consider that when I spoke to a prominent real estate attorney at length recently, that as he pulled up on all his screens, he said, why aren't they choosing to go down Wire Road? And I said, do you think this county has a really developed study? And he looked at me and just smiled. That needs to be done before these decisions are made. The growth is happening. I know it's a struggle for all, particularly sitting at this board. I can only imagine the decisions that have to be made. However, you know, what the county is capable of and does, and the financial future of all involved, right down to Mr. Hensey and Mr. Lane, can all be done in such a way that, in a more educated manner, that benefits everybody. And that's what I'd like to say. Thank you.
Anyone else?
Jimmy Lane is a representative for the applicant, so.
Jimmy Lane, 16300 Old Kelly Road, Van Cleve, Mississippi. I share the concern with the community as everybody else that has spoken and everyone that signed that petition. And I'm going to make a decision here, but it's not going to be based on anything other than the pure need to kind of get along with the community and make it work. It does not diminish the fact that this property is geographically and geologically one of the best sites for a Class 1 pit in this county. I think done right, it's a good area. It's surrounded by paper company property. The pit certainly existed prior to a lot of these homeowners. Many of them was aware of it. And I'd like to mention part of the reclamation of a pit of this size is a Class 1. While they do have a Class 2 designation, you know, with time, it helps with reclamation. But at this time, I'd ask y'all just to pull it, and we won't pursue it any further. And I appreciate y'all's time, and I apologize for the delay.
Thank you, Jimmy.
Thank you, Jimmy.
So he's pulling his application. Since the planning commission approved that, do we need to do anything here, Jimmy? Since he's pulling the application, that should suffice, correct?
No, I think we'll get an order entered that the application was pulled. He did have, I think, authority to speak on behalf of the applicant, correct?
Yes, sir.
Yeah. We'll get an order in that basically says that, that he withdrew the application. I don't know that we need any action to be taken.
Okay. Good deal. Thank y'all.
Thank you.
Jim.
All right.
Yeah, on second thought, let's get a motion just declaring as moot that application, and I'll put that in the order.
A motion declaring what now?
As moot, in other words, it's over, it's done, kind of a legal term. Just if we get a motion declaring that application is withdrawn and moot, and I'll
Okay.
prepare one paragraph.
I'll make that motion.
Motion by Mr. Commerce, second by Mr. Bozar. All in favor by saying aye?
Aye.
All opposed? Ayes has it. Thank you. Okay.
Okay, I'm gonna get to the site plan here. I'm sure they're gonna take over the computer here in a minute. Okay, December 17th, Planning Commission, they considered the application RZON-11-2025-00147, and this was a request to rezone approximately 8.921 acres that was A1. They wanted to rezone it to C3, Highway Commercial. The applicant is Pure Country Express LLC. The property owners are Maxie Roberts and Mary Melvin. Surrounding properties are zoned A1, R1, and C3. The subject property is not located within a special flood hazard area. Donald McDonald spoke on behalf of the applicant, addressing growth along I-10 corridor and the volume of traffic traveling through the area, although he submitted no supporting data for this. The Planning Commission determined that he met the criteria for a zone change, and they voted 4-2 for approval. Of course, the criteria for a zone change was there an error made in the original zoning designation? Has the character of the neighborhood changed to such an extent to justify rezoning? And a public need exists. Lisa Cannon has submitted an appeal application, and she's present to state her case.
Ms. Morris, before Ms. Cannon speaks, can I go a little bit deeper with what Marcus mentioned? And I read this entire file, and in the transcript, you went through the criteria that are needed, and the Planning Commission saw fit to approve it. So let me just go through this, because this one is a little bit different. I don't recall seeing one just like this that deals with property right off the interstate. But remember, on a zoning, that it has to be proved by clear and convincing evidence. In the legal world, you've got preponderance of the evidence is the lowest, clear and convincing evidence is in the middle, and then beyond a reasonable doubt, which is typically what you have for criminal cases. But you have a heightened standard that the applicant has to prove in order to rezone. And the reason for that is, if you read all the law, once a zone is made, once zoning is done, there's kind of the intent that be, quote, permanent, right, until something changes that warrants a rezoning. So mistake came up. I don't know if that was one of the original reasons to have this rezone, but mistake came up in the discussion before the Planning Commission. And a mistake is not that this board thinks that somebody previously should have zoned this another way. That is not a mistake. Y'all not challenging their wisdom from however many years ago when this was zoned, general agricultural. A mistake is basically a clerical or administrative error, not a mistake in judgment by the zoning authority. So there has to be some proof brought forward that there was an error, that there was a mistake in that zoning. So, and that has to be brought forward by the applicant. And I don't know if that's going to be alleged this morning or not. But then what's required, let me go into what's required to prove the change in the character of the neighborhood. you have, the applicant's gonna have to show that the neighborhood's character's changed substantially to justify rezoning. There's gonna have to be evidence that's brought forward, such as maps, showing changes, statistics of growth, charts, showing construction quality or evidence of recent rezoning in the area. And the reason I'm saying this is a lot of times people come before the planning commission and the board and they just say things, right? And you've got to bring forward proof. If I went to court and just got up and started talking, that's not proof to the judge or to the jury of my case. So there's gonna have to be some proof that the character of the neighborhood has in fact changed. And then public need, that's kind of the one where it's hard to really define what public need is. But I will say there has to be a legitimate public necessity that exists for the proposed zone change. And if y'all recall, in that Marcellus case that came from this board and we appealed, or there was an appeal to the Supreme Court on public need, there has to be something brought forward by the applicant. In the Supreme Court in that case, or the Court of Appeals, Supreme Court, said that the have to bring forward data, statistics, things like that. That was for the Marcellus case. You can't just say that a public need exists because of X. You have to bring something before this board. So
That's correct.
I kind of bring that out. I wanted y'all to hear that from me before you hear whatever is brought forward by the applicant or the opponents to make your decision. And it's, again, this is a little bit of an unusual one right off the interstate. I don't think I've seen one like this before. But anyway, those things have to be proven rather than just said.
Right, and that's, and Mr. Comer's correct, and that's why I said, you know, the planning commission voted 4-2 to approve it, although no data was submitted, so they didn't submit any data to approve it.
Correct. Yes.
But Ms. Cannon is here to present her case.
Good morning. Thank you for allowing us to come forward to hear the appeals process on RZON TAC 11, TAC 25, TAC 00147. My name is Lisa Clark Cannon. I reside at 13017 Forks Lake Road, and I am here in the appeal process regarding changing this property from general agricultural to highway commercial. Under Jackson County zoning law, and of course, Mr. Comer just recited it, but I'm going to restate. A zoning may be approved only if the applicant either proves a mistake in the original zoning or both a substantial change in the neighborhood and a demonstrated public need. In this case, during the Planning Commission meeting, none of this was presented as evidence. It was just purely stated. First, there is no mistake in the original zoning. This property has been zoned agricultural for many decades. It is consistent with the surrounding properties and the land use. There is no mapping error, no mistake shown there, no clerical error, and no planning mistake was identified. The reference to the nearby interstate being put in does not constitute proof of a zone change mistake. These were opinions that were offered and no factual evidence was presented. Second, there was no substantial or is no substantial change in the neighborhood. This area remains rural and agricultural. A single dollar store is located about a half a mile away, and certainly that does not represent a material change. They are also zoned agricultural. Inside the Planning Commission transcript, it states that there are two churches locally, and that both of those churches are commercial, when in fact they too are still single-family residential zoned. So there was no zone change there for those two churches. The existing caution lights was brought up. Those caution lights are there for commuter traffic. It's not that the neighborhood has grown to the point of meriting caution lights or traffic lights. It is commuter traffic predominantly coming out of Mobile, and they're commuting to and from work here in Pascagoula. There have been no infrastructure improvements. that would essentially be needed in order to support highway commercial use. In addition to that, the comprehensive plan that Jackson County currently has on record designates this area still as agricultural and residential. In addition to that, there is an abundance of property that is appropriately zoned along Highway 90, south of I-10 on the Franklin Creek area and on I-10. None of that's been developed, and if it has, it's very old businesses, most of which are out on Highway 90 near the Alabama state line. Third, public need. There is no demonstrated public need. The rezoning primarily benefits private financial interests. The purchase contract that is on record is contingent upon a rezone approval. There was no market study, no demand analysis was submitted, and commercially zoned property, again, already exists. The developer could strictly pursue some of that property that is already zoned appropriately. This request, in my opinion, does not support any type public interest. Finally, highway commercial zoning is incompatible with all of the surrounding areas. It does abut a very small portion of commercial property that is closer to the interstate, but if this is changed, then certainly there's going to be infrastructure that needs to be installed, and I would guesstimate that that is going to be the cost of the county, on us as taxpayers. How can that be right? For these reasons, I respectfully ask that you reverse the Planning Commission's recommendation and deny the rezoning in accordance with the law and your own comprehensive plan. Thank you so much for your time and consideration. I know there are several people in the audience that wish to speak as well, and I would like to turn this in as part of the evidence.
And at least to Mr. Catchart, he'll make that part of the record.
We'll get to the zoning map here so you can see.
Can I mention one more thing while Marcus is getting to that? In the Planning Commission transcript, there was talking about a truck stop or a gas station.
Yeah.
All that's irrelevant.
Irrelevant.
It's all irrelevant. I don't know what all is allowed in highway commercial, but when you rezone something, anything that is allowed to go like this, if you were to rezone it highway commercial, anything that's allowed to go in highway commercial could go there. The fact that somebody may want to put a truck stop or a gas station there, if it's rezoned, could change your mind before the sun sets. So that comes up a lot, but
if it were rezoned, they could actually do anything that was allowed in the C3 zoning. They don't have to do a truck stop.
Correct. Yes. Yes, sir.
Okay.
Okay. Anyone else want to speak?
What is the red and yellow up there?
That's C2 commercial, and the yellow is R1 residential. The C3 is the zoning that they're trying to get, and that's the C3 that's along Interstate 10 there, you see.
Okay.
And this is the brown. This is the property here in question.
Good morning, Board. My name's Fred Presley. I live at 9701 Sandy Lane in Moss Point. I am here in opposition to the rezone. The last four digits is 0147. Maintaining consistency with surrounding zoning is essential to fair, predictable, and responsible land use planning. This property is primarily bordered by R1, single-family residential, and agricultural 1, which reflect the established character and expectations of the area. Introducing highway commercial 3 zoning in this location excuse me, would create an incompatible land use pattern, undermining neighborhood stability and potentially impacting traffic noise and property values. Zoning decisions should reinforce coherent development rather than introduce isolated exceptions. Denying this request preserves the integrity of the zoning framework and protects the character of adjacent properties. Please consider denying this zone request. And I'd like to enter this as record.
We'll take that out. Thank you.
Thank you. Thank you.
Good morning. I would like to enter this as evidence. I have an extra copy if anybody else would like to see what I have. I'm Annette Stringfellow, residing at 13137 Forts Lake Road. I'm familiar with the subject property and commute daily through this area. For brevity, I incorporate the presentation that Lisa Cannon just made for the reasons to deny the appeal. I add the following. There has been no substantial change in the neighborhood. There was information given to the Planning Commission which misrepresented the facts. A realtor, Mark Cumbus, who represents the property owners of the subject parcel, testified to the commission that the character of the neighborhood has changed. That's Exhibit A. Mr. Cumbs' words have no weight, and there was no evidence offered to support his statements. A Public Records Act request was made to the Jackson County Administrator's Office for a list of issued building permits of new residential homes in Jackson County, and it returned a list of containing 850 residential permits from 2024 and 2025 within the county's jurisdiction, not just in the area, the subject area. The addresses from the list were cross-referenced throughout the county. The list was imported into a Google Maps program, and it created a computer-generated map that automatically placed a marker showing each address of a new residential building permit issued. That's Exhibit B. The map of the subject area, which is from points just south, east, and west, and north to the Forts Lake community, onto the Mississippi-Alabama state line, does not show any issued permits in the area for that time frame. Therefore, according to the county's own data, it does not support Mr. Cumbs' claim of a substantial change to the neighborhood. Mr. Cumbs also said he considers the Forts Lake community to be part of the neighborhood. I have lived my entire life in Forts Lake community and knowingly say that there has been no substantial change to the neighborhood. Mr. Cumbs told the commission, look at aerial photography over the past 10 years to see that a great number of homes have been built in the area. Exhibit A also. Here again, Mr. Cumbs' words have no weight and without evidence have no merit. Using Jackson County's GIS mapping resources, a comparison of the area was made, not just for 10 years, but 12 years. As you navigate through the mapping, there is very little residential growth of the area. As a matter of fact, you find only a handful of new homes in the Forts Lake community. And the new residential homes shown in the maps in the Forts Lake community are mostly a family, consisting of children reaching adulthood and building on or near family land. Yes, growth, but not a substantial change to the neighborhood. The same can be said of residential growth closer to the subject property. It is so little that it doesn't fall within the category of substantial. For Mr. Cumbus to indicate to the commission that the area is growing by leaps and bounds is nonsense on stilts, has no merit, and does not provide the evidence needed to meet the criteria to support the mandatory requirements for rezoning. There is no substantial change to the neighborhood, and a public need for rezoning does not exist. I've attached the exhibits that I've mentioned to my statement that support my findings. I respectfully ask the board to grant this appeal and deny rezoning of the subject property. Thank you for your time and consideration.
Thank you.
Marcus, I've got a question. Like on the C3 zoning that runs along the interstate, how deep is that?
I didn't measure it. I'm not sure exactly, Mr. Ross. It looks like it, usually something like that stretches out 250, 300 feet. But you have to give your name and address before you talk.
Hold on.
Reporters, so give it just a second. Okay. So. Court order's just trying to take everything down. Gotcha.
My name's TJ Lehman. I live at 9100 Franklin Creek Road, which is right around the corner from this. And what I wanted to focus in on, because everything else I feel is covered, and it seems like you're a little bit interested in it. It's hard to find exactly the measurements and the amount of land that you have on the GIS software, but there is actually a measuring tool. And I did my best to measure out all of this C3 and C2 property that's along I-10 and Highway 90, and it's just over 200 acres approximately. And in that batch of property, all of the C3 that is along the interstate
not a square foot of that is developed. It's all vacant. This, this parcel right here is a newly rezoned spot. There is a business there, but all the rest of that, like I said, it's not even developed. There's nothing on it whatsoever at this time. On the C2, right in this area, there is a couple of buildings. There's a residence right where I put the crosshairs, and then there's a like a vacant shop or something here. This parcel right here, I want to put your attention on. If you notice the way that the zoning kind of changes, it's a different contour from what else is already up there. That was already at one point it was a big commercial area, a convenience store type of thing there. And just for reference, it's also owned by the same person that owns the parcel in question. So my point is there's over 200 acres of commercial property already zoned, ready to go. And it's been that way for at least the 20 years that I've lived here. And there's absolutely nothing on it except for weeds and trees.
Sir, could I ask you a question? You mentioned a minute ago there was a rezoning somewhere else, and I was lost as to where you were.
Yeah, right. Can you see it here? Now, it's on Old Stage Road. Can you see the crosshairs moving?
That was rezoned to,
It was rezoned to C3. Yes, it's I can't remember the name of it. It's a cannabis business.
And just for the court reporter, Mark, is that correct, Marcus?
Yes, sir, that's correct. It was rezoned, but it abuts the interstate.
Right, that's on the, for the court reporter, that's on the south side of the, I-10, correct, yeah.
Yeah, it's actually on Old Stage Road.
Okay, thank you.
So, but that was my main thing. I just wanted to put y'all's focus on the fact that there is plentiful C3 already there, and I feel like the statement that, you know, this was zoned before the interstate was there, that's kind of a bogus claim that was made at the last meeting, because clearly all that C3 was put there, zoned in with the thought of, you know, development right by the interstate.
Thank you.
All right, thank you all for your time.
Anyone else?
Mr. Morris, I would like to ask one more question, ask Marcus's thought on this. In reading the transcript from the Planning Commission, when we talk about public need, there was kind of two different, quote, public needs, right? One may be public need for someone driving down the interstate to utilize whatever would be built in this area, because there was discussion about where are the exits that have development before and after this particular intersection. The other, quote, public need could be the public need for
the neighborhood.
The neighborhood. So,
Correct.
right. So what public need do you look at? I mean, there could conceivably be public need for the neighborhood with no public need for the interstate travelers, or this could be solely public need for the interstate travelers, if I'm driving down the road, pull off to whatever the development may be, and zero public need for the residents, right? So that's a tough question, and the law basically allows you as the body, you five gentlemen, to kind of decide what
the neighborhood is.
What the neighborhood is and what the public need is. But I could see two completely separate public needs, right?
Correct.
And which is unusual, which is unusual. So
right, right.
Good morning. My name is Mary Presley, and I live at 9701 Sandy Lane in Moss Point. I'm here to appeal the Planning Commission's recommendation for the rezoning in case that ends in 0147. The county law is clear. Rezoning is only allowed if there was a mistake in the original zoning, or if the area has truly changed and there is a real public need. That didn't happen here. The land has been agricultural for decades, just like the surrounding property, and no zoning mistake was shown. This area is still rural. One Dollar General down the road doesn't change that, and the comprehensive plan still calls this an agricultural area. There is no demonstration of public need. This request mainly benefits private interest. There's already commercial land nearby sitting undeveloped. For those reasons, I respectfully ask y'all to deny this rezoning. Thank you for your time.
Thank you.
Thank you. You want to submit that for the record?
Yes.
Thank you.
Anyone else?
Someone else?
Good morning. My name is Betty Hurd, and I live at 9317 Forts Lake Road, Moss Point, Mississippi. I'm here to respectfully appeal the Planning Commission's recommendation for rezoning case 00147, which seeks to change our lovely agricultural property to highway commercial. Now, I'd like to point out that there hasn't been a mistake in our agricultural zoning. It's been this way for years. This area remains rural, and just because there's a Dollar General a bit down the road doesn't mean it's a significant change. Plus, there's no real public need for this. It mostly benefits private interest without any solid market analysis. So I kindly ask that you deny this rezoning request. Thank you so much for your time.
Thank you.
Thank you.
Anyone else?
Morning. My name is Thomas Pattison, without an R, and I live at 12321 Congress Road, Moss Point. I'm here about the rezoning, and I'm not going to read all of it, 00147. This land had been agricultural as long as most of us can remember, and the area around it is still rural today. Our county rules say that land should only be rezoned for a real reason, and that just hasn't been shown here. The change mostly helps a private deal, not the folks who live and work around it. Also, the need for interstate, per se, stopping there. They have a place 6 miles to the west, 4 miles to the east. They can stop and get fuel, get whatever they want. So therefore, I kindly ask you all to deny this rezoning. Thank you for your hearing me out.
Thank you.
Good morning. My name is Anita Crosby, 12925 Forts Lake Road, Moss Point. When the Planning Commission was hearing the discussion about rezoning at the previous meeting, they repeatedly asked for discussion to stick to the 3 requirements for zoning. They heard an opinion from a surveyor from Jackson who would profit from the change. He stated that he believed the current zoning was a mistake but had no substantial proof. They heard from a realtor who also will gain from the change. He stated there had been substantial growth, and as you've heard, he had no proof either. I'm in the process of trying to sell a house. All of the realtors that I've spoken with have made sure to point out that we are in an undesirable area because of the school district we're stuck in. We have become a very nice retirement community as a result of this, but there is almost no growth or change in our area. Ms. Stringfellow showed you the proof. There was discussion of great need for development as gas stations, convenience stores, etc. We have gas stations and convenience stores within a drive of 2 minutes or 7 or 10 minutes, which way you're going. We're not in need of more convenience stores, and by the way, that accounts for the people traveling the interstate. They have opportunity 6 minutes down the road, 10 minutes down the road. So we are not in need of more gas stations and convenience stores, and neither are the travelers on the interstate. The Planning Commission did not meet their own criteria before they voted to change this area zoning. So I'm asking you to listen to the voters who live right here and will only lose from this rezoning. Thank you.
Thank you.
Anyone else?
Yes, my name is Lewis Hurd, H-U-R-D. I live at 9317 Fort Lake Road. I'm here to talk about the rezoning of 00147. I just want to say something. I've got a paper written down, but I think I'm just going to talk and tell you. This piece of property here, right here, is been there and been rezoned there as agriculture. All this property here is all C3. And a while ago, a guy said that this guy that's selling this property owns this property right here, which is already zoned C3. Why not use that instead of coming down this area here that's got a 2-lane road? This is 4-lane here. Would make more sense than rezone this to commercial. But, you know, they also said that we've changed in the community. We've not changed. I've lived there all my life, and it's basically the same thing. I drive by there every day, and it looks the same no matter what. We have a Dollar General just put in a couple of years ago, but that doesn't constitute a change. So I would like for you to just not approve this. We don't need added traffic in this area. Thank you.
Thank you.
Good morning, my name is Mikey Maples, and I live at 12201 Maples Lane. I'm here to appeal the Planning Commission recommendation on zoning case 00147. Our zoning laws say land should only be recognized for a good reason. This property has been agriculture for a long time. The area is still rural, and the comprehensive plan says it should stay that way. This change doesn't meet those standards and mostly benefits private interests, not the folks who live there nearby. I respectfully ask you to deny this rezoning. Thank you for your time.
Thank you.
Appreciate it.
Anyone else?
Okay, Donovan Scruggs is here representing the applicant, and I think he has some information that wasn't submitted the first time here.
Excuse me, may I address what Mr. Conroe was talking about with neighborhood? Is that appropriate at this time?
Mr. Coleman, I think he's up. That's up to the
You'll
board.
have a rebuttal after Donovan gets
Yeah.
through. Yeah,
Okay, thank you.
all right.
You want to use it?
Yeah.
Come on.
How are y'all doing this morning? Hope I'm not holding y'all up from getting over to Biloxi for the Mardi Gras festivities. Let's see here. All right. Good morning. I'm Donovan Scruggs. Ms. Roberts has asked me to assist her with the rezoning of this property that has been mentioned, was passed by the Planning Commission in the 4-2 vote. we've gone over where the property is located. It is at the off-ramp of Interstate 10, which makes it an idea for commercial use. This is a zoning map that you guys have looked at today. I do want to point out that the property is actually split zone. Whether it's a large portion or not, the property is split zoned, which is something that is typically looked at as less than positive in your zoning regs. Everybody's got two zoning if it is split zone. And a portion of it's zoned A1 and a portion of it is zoned C3. And when you calculate, as somebody mentioned here, there may be 200 acres of C3 zoning that is out there. If you say 100 that is north of the interstate, then you can look at this map and say how much of it has access. How much of the C3 property on the north side of Interstate 10 has direct access to a road? Zero. Zero. It's a split zone property that's basically rendered a good bit of this useless. I'll get into some other change in neighborhood character here in a minute that further makes a lot of this property out here difficult to develop. But this demonstrates to you, that within this area, certainly this property is zoned A1 and C3. Property to the north has been rezoned to R1, which is a more intensive use than the A1. You've given a special exception to a Dollar General, which is a change in neighborhood character. And you've got another store to the north of this, which is Zone C2. And I don't think anybody here is saying that those C2, the convenience store here or the convenience store further north has deteriorated that neighborhood. Sometimes having goods and services available to you is actually seen as a positive. Otherwise, you've got to drive to Moss Point or Mobile to get what you need. Now, changing character can be looked at as a number of different ways. Back in the early 80s and 70s, there was no flood maps. And in 87, there were some changes to the flood maps that showed this entire area was basically outside of a flood zone. Well, in 2009, after Hurricane Katrina, those maps were revised. And with that, on the north side of the interstate, almost all of the property outside of this property and the adjacent one to the east were deemed in a flood zone. That makes it more costly to develop and more difficult to develop. To me, that's a change in neighborhood character. And if you don't believe me, ask anybody in Pascagoula that's had their property designated in a different zone that now makes their property undevelopable, or at least they cannot do any additions to it. Flood zone impacts are real, and they do change the neighborhood character. Now, this doesn't even count the implications of wetlands out there. Everybody said, look at all this property. It's all available. It's great. It's all zone C3. What do you need to do? Just go build on it. That's not the way it works, guys. We all know that. Wetlands are a deterrent to development. This particular site is approximately 60% or 70% dry, meaning that it's not deemed wetlands, meaning it is developable. And that's one reason that this site is being looked at as opposed to sites to the south that are wet and cannot be developed. So,
Hey, Donovan, can I stop you right there? So on the 2009 map that you're showing up there, everything that's in blue is in an AE flood zone, is that correct?
That's correct.
And then the other areas that are brown, I guess, are not shaded, are outside of the flood zone.
That's correct.
Okay.
The grade on the bottom is a special flood.
Yeah, but that's in 87. I'm looking at current, yeah. And so all the property that's zoned, or a lot of the property that's zoned C3 south of the interstate is not in a flood zone.
It's not, but it's very wet, Mr. Fulton.
Okay.
And then I'm going to get into some more stuff about south of the interstate as well. Oh, here we are, south of the interstate. Somebody said that all the adjacent property owners actually are against this rezoning, and that's not accurate. That's totally inaccurate. In fact, we've got a petition that I put before you that demonstrates the property owners that are adjacent to this actually have signed a petition in support of the rezoning. Meaning that the ones who are actually close to it and not 4 miles up the road is in support of this rezoning. Now, if you look also to this property to the south, you're going to see a bunch of things that says USA. It's a very patriotic area because the state, the federal government, and even the Jackson County has gone in and purchased a lot of the property to the south and made it undevelopable. To me, this is a pretty significant change in neighborhood character, meaning that it removes property from private development. It makes the property public and undevelopable. A lot of this was a direct result of the property being deemed in a flood zone or too wet to be developed. So that gives you an idea of what some of this area is. And the fact that this property is actually, I'm not going to say high and dry, but it definitely has potential because of the lack of wetlands, or at least the diminished wetlands on it. This county has done a great job in planning, and not a lot of counties do long-term planning and zoning. If you look at prior to the annexation of Goshen and Ocean Springs, the county had that interchange at 57 and Interstate 10 designated as commercial. That's appropriate. The same thing goes with Highway 609. That area, the interstate north of Washington, were always zoned as commercial. That's what you do on interstate zoning. This map shows you that the Goshen, but also the 2 exits in Moss Point are zoned commercial. About the only one that's not is the Sand Hill Train Refuge, which is zoned public at the over in Goshen. So it's not uncommon, and in fact, it's typically the rule of thumb that interstate access points are zoned as commercial. Look at everything in Harrison County, look at everything in Mobile, and you'll see that primarily interstate changes are designated as commercial. Now, I do think, Mr. Comer, you mentioned public need can be looked at in a lot of different ways, but I do believe that split zoning is terrible. And it serves a disservice to the property owners who are the public and who cannot develop their property the way it's zoned. It's great to have C3 zoning, but if you cannot get to it, it does you no good. So I think it would be very advantageous for the property owners that have their property split zone to actually pick a side and go with it and make it all more complete.
Let me ask you a question if I can. On that split zoning that you're saying, are you alleging a mistake or just, I mean, because mistake was up there and
yeah. There's a tiny bit of this property at the very bottom that encompasses the C3.
Yeah, I'm just trying to make sure that.
Right, no,
What you're saying.
I'm not arguing a mistake in zoning in the legal sense, but I do think that it is a zone, it was a decision, it was a bad decision. As you said on the front end, you can't call a poor decision by a board being a mistake in zoning, and I agree with that 100%. But I do think that it was a disservice to these property owners who had their property split zone, and they say, hey, look, your property is zoned C3, highway commercial, great for the interstate, but you can't develop it. You might as well, put something out of reach, because that's what's happened here. Coupled with the federal government's definition of wetlands and everything they've done, that area is, even though it has highway commercial development, highway commercial zoning, it does not really afford them the opportunity to develop accordingly. Leave this property as agricultural. What are you going to do on 5 acres or 8 acres of agricultural land nowadays? I recently sold some pine trees, and I tell you, it barely paid the taxes. So silviculture is not an option. 5, 8 acres is not really adequate to do any farming. If you do cattle or sheep or anything else, they could wander and get onto the interstate, and you've got yourself a pretty high lawsuit. I don't know what can be done on this property. You cannot use it for residential purposes because there's 47,000 cars per day driving along the interstate. That is not ideal for residential development. I believe that the applicants have rightly requested a rezoning to a highway commercial that really mimics the way y'all done everything all across the county. If you're going to allow highway commercial property, at least allow the frontages of the access roads to have that commercial zoning. It really benefits no one to have commercial zoning that you cannot access. Now, I know there were some petitions filed, you know, and sometimes I get, you know, dig down in the weeds and look at various things. But this map kind of shows you where a lot of those who signed the petition came from. I'm not saying that everybody on the petition was outside of the area, but you know, some of these folks are 2 to 3 miles away. Heck, I might as well sign the application Motion Springs said I was for, you know, because when you're 4 or 5 miles away from the site, it's hard to say by any definition of neighborhood that this is within that neighborhood. This would be about like me in Ocean Springs opposing a rezoning, you know, on the north side of Washington Avenue near the interstate. Now, there were approximately 6 individuals on that petition that were in a half-mile area. And I think that's a little bit easier to look at. But I think once you get into 1 or 2 miles away, you're really asking, you know, how does this really impact them, and what are their motive here? I don't understand it. Everybody drives by a gas station on their way to work. I've got one within a half mile of me, and it does not affect me one way or another. So to say one that's 4 or 5 miles away is going to have an impact on my neighborhood is I've probably been a little disingenuous. Now, you know, Miss Cannon, you know, I think she lives about, you know, over 4 miles from the site or 3 miles from the site, and I think you know, a couple more that spoke are in the same area. In fact, you know, at the planning commission meeting, it was ironic that one individual actually stood up and said, I guess I'm the first one in this group that actually live nearby this where we want to develop this gas station. I mean, even the guy who was there to speak against my property or my site acknowledges that the majority of people that were there opposed to it didn't live next to it. So I don't understand the adverse to this, but you look at the proponents, and once again, there's a site in the middle. You've got a bunch of blue around it. That blue are people who have signed a petition that said they are in support of this rezoning. I do agree that with Ms. Cannon in that churches are not commercial, but they are non-residential. And if you look along the north side of Independence, you're going to see that those properties are non-residential in nature. You've got Franklin Creek, you've got another church property just north of this who actually signed the petition to support the rezoning. And then you've got the Dollar General. You've got Mr. Lambert's property to the west that is also, you know, commercial purposes. So there is property that is in immediate proximity to this that is non-residential or commercial in nature. There was a lot of conversations about traffic on this road and how it would be negative if this occurs. You know, as somebody mentioned earlier, it's going to be getting off and getting on, getting off and getting on, or getting off and going to Ingalls. I believe they said that the majority of traffic that comes through here is going to work at Pascagoula. So I don't believe this is going to push more traffic up on Forts Lake Road. Comp plan actually identifies this as a potential commercial node near Interstate 10 and Forts Lake Road. So your comp plan actually zeroed in on this property and said this is a good spot for it. Your comp plan also said that one of the weaknesses is the limited amount of off-highway development at certain intersections. And a lot of this was due to the potential low elevation. This is a property that actually has high elevation and should be consistent with the comp plan as far as what it says with developing nodes. I know a lot of this is probably concerned about annexation. This property owner should not be held hostage while Pascagoula decides, you know, how it's going to grow or not grow. Pascagoula has been struggling for years with population growth, and I think they're going to have a hard time saying that this area is in a path of growth when they are not growing. And I do know that Mr. England and Mr. Wiggins are working hard to, put together some legislation that will slow down or deter the annexation of this by Pascagoula. So let's not hold this property up in some kind of thought that this is going to be the main indicator that gives Pascagoula all of a sudden a reason or a chance to annex. Let's see. The planning commission voted 4-2 to approve this, and our property owner, who has owned this property for more than 80 years, she didn't buy it to flip it. That her family has owned this property for more than 80 years, and there's an opportunity, and she's finally, coming forward and saying, hey, I can do this, and I hope you guys will, work with her and give her the rezoning as recommended by the planning commission. I'll be happy to answer any questions, and I know there's a few people here to speak up for this.
I do have one question just for clarification on the church. I've heard two different things. It's zone commercial, it's not zone commercial.
It's a commercial use.
I said it's a non-residential use.
It's a C2 zoning, commercial use.
The churches are,
Church is allowed in C2.
okay.
It's a special exception. I'm sure is what happened with that church years ago.
Is it zone residential with a special exception?
I'm assuming that church has been there for years and years. If you wanted to build a church, it'd have to be C2 zoning.
Church could be grandfathered too.
Yeah.
Yep.
All right.
Hey, Donovan, I had a question too. Can you pull back up the map that were the people that were in favor of? That one. So are any of those, I guess, how many of those are residential in nature? Are any of those residences, or is that vacant property owners?
It's a lot of vacant property owned by different individuals, but it is property owners, taxpayers.
Yeah.
There are properties within this that are residentially zoned and residentially owned.
Is it, how many property owners does that represent?
I've got the petition in front of y'all.
Okay. That's good. Thank you.
30 maybe.
Thank you.
Anybody else here for it, want to speak?
Good morning, and thank you for your time this morning. I'm Maxie Roberts. I'm one of the owners of the property under consideration for rezoning. I live at 61 South Monterey Street in Mobile, Alabama. And even though I'm from Alabama, I'm really a fifth-generation Jackson County person. My father was born in a place called Big Point, Mississippi, which is really in the middle of Jackson County. And his family had lived there for 4 generations. Our family owns about 2,000 acres in Jackson County, about 800 acres in this area. So we have a lot of ties, even though we live in Alabama. And we love this part of the state and this area. So I have before you a letter that my sister and I prepared and submitted to you, and I'd like to read part of that. I think Mr. Scruggs, who has assisted us, has very well stated the issues relating to the character of the neighborhood, changes, and public needs already to you. That is his expertise, and we support that and adopt that. As I said, our family has owned 800 acres in this immediate area of Jackson County, Mississippi. Since the construction of I-10 and the development of the Franklin Creek Road interchange in 1966, it has been evident that this property would become public use or commercial use at an appropriate time, and that was really the highest and best use for commercial use. Along the Mississippi Gulf Coast, the vast majority of the I-10 interchanges have already been developed in this manner. In the late 1960s, on the southeast corner of the Franklin Creek Road exit, our father, Mac Roberts, leased the property to a Mr. Burt Lawler for a convenience store and gas station, and that's already been referenced, which served the area for some years. This use was consistent with the commercial nature typical of interstate interchanges, and that principle exists today. Rezoning the property to commercial use supports responsible economic growth in Jackson County and reflects the appropriate development of interstate frontage. Commercial zoning at this location will enhance the county's ability to attract business, to serve interstate travelers, and strengthen the local economy. We appreciate your time and consideration. I know that the Planning Commission voted in December to approve this rezoning, and I know they've looked at that with diligence, and we appreciate your review of this matter as well. Glad to answer any questions that you might have, and I believe the letter is already before you.
Any more questions? Thank you.
Thank you.
Anyone else?
Thank you.
My name's Mark Cumbus. I'm the owner of Cumbus Realty, 17732 Highway 63. As I hear people talk, I see several holes in the points that the opposition's trying to make, and I'm just going to be blunt about this. I mean, I'm not trying to win any popularity contests. Jackson County is a very, very wet county. Limit properties that are zoned commercial, you got to look with a magnifying glass to find properties that have the possibility of good access. You can't get, you got to check with Mississippi Department of Transportation. There are just many zone properties, commercial, that just are not accessible. You add on top of that, commercial properties that are in a flood zone, a bad flood zone, that limits it further. You add to that the wetlands that are here, and that's the way the good Lord made it. We just live in low country. We live in low country. All right. A person wanting to build a store, okay, it's like finding a needle in a haystack. The choices are not not big choices, because fortunately on this one there's just enough non-wetland that the purchaser can mitigate and add to the footprint in order to even use the property that he's buying from Ms. Roberts. I didn't bring a wetlands map. Do any of y'all have a wetlands map of this? I mean, it'll blow your mind. Okay, so we're dealing with that, and we found a buyer who is willing to make the investment, to invest, to mitigate for this land, to use it for what he needs it for. And I'm going to go ahead and tell y'all right now that this deal is contingent, this contract that I prepared between Ms. Roberts and this purchaser, you know, is contingent upon the zoning. Well, just 2 weeks ago, I found a purchaser. I brought to Ms. Roberts a purchaser of the land that she owns on the west side of this property, across the street. What does he want to do? Because there's not a whole lot of wetland there, and because it does have reasonable access, he's wanting to put a store. He's wanting to put a commercial business. And it's under contract. Y'all be seeing us again because there again, it has the split zone, which is basically I call it a curse. You get a split zone, you don't have anything. I mean, it might as well not be zoned at all. And so I just want to dispel the notion that here we are in Jackson County. It's not like Texas. It's not like my kids are in Texas. It's not like, you know, everything's out there, just build whatever you need to, as long as you think you make some money on it. You got to deal with how the good Lord made this area, and it takes people with deep pockets to be able to do this. And fortunately, we've got a great business. This guy is in a, he's got a proven kind of a trademark. He's got a lot of the stores he has done is, you know, very, very good, very, very well done. On this particular property, he's going to have PJ's Coffee Shop in there. I mean, actually a full setup for PJ's Coffee, which in my opinion is better than Starbucks, but hey, who am I? Then he's going to have a Subway. He's going to have other things. We're going to have about 10,000 square feet. I mean, this is not some mom and pop fly by the seat of their pants deal. I mean, this guy's a pro, you know, and I just, okay, and there's a long way between the Grand Bay exit and Highway 63. Lady a while ago said, you know, you can drive, you know, 7 minutes and you can get, you know, some fuel. And I've done this before. Your gas needle is on E. You're going to have to drive a lot more than 7 minutes to get fuel. If you, now with this thing, this is one of the largest areas that there is no place to buy fuel. I mean, think about the travelers on I-10. It's a great, I think it's going to be great for the community. I think once it's built and you drive by there, I guarantee you, the opposition might go in and fill up and buy some TJ's coffee. PJ's coffee, I meant to say. But anyway, that's all I've got.
Thank you.
Can I ask a question just for clarification for the board, because it's important, y'all? Mark, you or Ms. Roberts or Donovan, is the public need that has to be proven by clear and convincing evidence, is it the public need for the residents or the public need for the travelers? Now, I don't know that one or the other is if it's the travelers, I don't know that that's fatal, because it's really kind of an unusual area. But I mean, the public need, I'm hearing two different things, and just want the board to take that into consideration. What public need are we talking about?
The public need, well, there's a number of them, Mr. Comer. One thing, if you look at, you know, zoning, any zoning ordinance or even the county's comp plan, it talks about having commercial nodes that are that can service the surrounding area. And like Mark just mentioned, while these individuals who are, you know, voicing opposition to this, they're going to be the benefits of it, whether they're happy with it or not. They will utilize the services of this convenience store for whatever it may be. And if it's not a convenience store and it is a you know, one of the many uses allowed in C3, a hardware store or whatever else may pop there, it's there to serve the community. While there will be some passerby traffic of the 46,000 on Highway Interstate 10, it will serve the surrounding area, which is what zoning does. I heard Jerry Creel today on the news planning director over in Biloxi, saying that you've got to have rooftops before you have the commercial aspect of it. You can't go out and just build commercial and hope rooftops come around it. So the rooftops, in this particular, the C3 uses, are there to service the nearby community. So that's a public need, whether they want to mention or not. There's not a place to get you a sandwich out there that I'm aware of. So that right there by itself is a benefit that will, be given to this area. The split zoning that I mentioned is very important for, as a public need for those who have split zone property along this road. So I think that's a public need. I think that, putting this property into production is a public need. Having property that sits back vacant, and I don't know what your tax assessment is on this property, but I bet it's not $100 a year. Whose pockets is that really doing anything for? It's definitely not the county. But if you get gas taxes and increased ad valorem taxes, then you're going to be looking at a benefit to the county right there. So there's a lot more public benefit to this actually happening than the adverse of letting it sit there. Letting it sit there is something for the residents who have opposed this to look at when they drive home and go, yeah, I'm glad I killed that project. I'm glad I can look at this, pine savanna or these pine trees or whatever it may be. That serves no public use, leaving it as it is.
Yeah, and really the reason for the board, I'm asking questions is this is an unusual piece of property because it's abutting an interstate and you have a neighborhood which I haven't seen one of those come before the board since I've been around.
Mm-hmm.
And that's why I'm asking about the public need. If it were somewhere in the country and there's a big residential neighborhood and nothing commercial, that's easy to see. This one's a little bit different. One thing I would like clarification on, Marcus, maybe, what all is allowed in a C3? Because we talk about a coffee shop, Mark, I don't doubt that maybe somebody has some plans for that, but
We can pull up the matrix.
uses of that property are irrelevant right now.
That's
What
correct.
C3 is C3 and everything that's in C3 can be built there. And
That's
so,
correct. We just have the criteria you have to look at, changing the character of the
Right.
neighborhood, and is there a public need, or was there a mistake in the original zoning? That's what needs to be looked at, not PJ's Coffee or Subway or any of the other stuff, because that could change. If it's zone C3, anything that's allowed in a C3 zoning would be allowed there. He could change his mind before, anything was built.
Right, and go ahead.
I mean, uses are,
a special exception or
repairs, boiler tank works, bookstores, bowling alley, business machine store, business college, cabinet shops, a cafe. There's a lot of uses that could be done other than this.
And I will say, we've looked at the chart of uses, and we can accomplish the same thing with a better or an alternative zoning, which would be C2. This is highway commercial, and it is your most intensive commercial district that is out there. But it's also the extension of an existing zone, and it makes sense. The C2 district is community district, which is it cuts the number of uses down significantly. And if this board sees a C2 as being a better fit, we have no issue with, that being modified. And I think I was correcting this, Mr. Comrie, correct me if I'm wrong, but the board can go down from a C3 to a C2 without a new public hearing or anything. It can go down, it just can't go up. I couldn't go from a C2 to a C3 because that's less restrictive and more intense, but I can go from a C3 down to a C2 as a means to accommodate or, the neighborhood.
Okay, anyone else for it?
And also earlier, just to clarify, we were talking about the churches. Churches are allowed in commercial zoning. We checked the matrix. They're also zoning, allowed in A1, so that's why it's there.
Okay, thank you, Marcus.
Okay, Ms. Cannon?
We do have some additional individuals.
Oh, yeah, one more, come on, okay?
Two more.
Okay.
Mr. George, it's very hard of hearing, so I'm gonna stand beside him to, interpret. I'm gonna use interpreter.
That's scary.
Name and address, please.
Go ahead, you state your name and address.
George Warden in Grand Bay. I'm a farmer, farmed all my life. I have land joining Miss Roberts on the east side. And she wants to go to C3. I have no objection whatsoever for her doing that. I know everybody wants to improve the property, even homeowners, anybody else. And that's what she wants to do. She's had that land for, like forever, and I've had my land for over 50 years. You know, someday I'd like to do something with it. You know, so that's one reason I have no objection to her going to C3. Thank you.
Okay. All right, thank you.
Anyone else for it?
Mr. Lambert? You're on, brother. Name and address. Name and address.
I'm Bobby Lambert. I own all the land adjacent to this property, and I have no problem with it. If anybody should have a problem with it, it should be me. The land is laid there and done nothing for 2,000 years. It's not farmable land. You can't farm it, and you need to turn it into something that you can make a revenue for the county. And this opportunity here, if you let it slip, you're gonna lose a big deal making money for the county. I've seen it happen at 63. And this is the last exit that land is available to build anything on. All other exits is bought up. And I've owned this land since 1962. And I was born and raised there in 1943, and I've been there 84 years. 82 years. And I suggest that y'all look at this proposition closed. And it would be a benefit to the county. To open this thing up and develop it. It would be a moneymaker for the county, and the county needs revenue. The land's only been laying there for 2,000 years, and it's nothing on it but frogs. You can't build a house on it. And I understand all the environmental. I was in construction for 50 years. And whoever comes in there, the owner, he's gonna pay to put good drainage, and he's gonna pay to put good roads in there. I've had to do it myself. The county's not gonna have a burden of putting money out on roads for this project. And you got people that don't even live in the neighborhood, and they all down here kicking against it. And I live right there at it. All my land is from I-10 to Independence Road, and it's adjacent to this land. And I-10 is traffic, they 50,000 cars a day going down that road. It doesn't bother me. And what bothers me is all the traffic that's going to Lytton and Chevron on Forest Lake Road in the morning and the afternoon. That's what, and in other words, and another thing, they built a dope growing facility within a quarter of a mile of my place. Now, nobody, heard nobody kick against that. It's okay to grow dope. Well, this deal here, it's a legal deal. This dope deal just killing people. But nobody went against it. But they built it, and they got it up running. And I would like to know how it happened. Can anybody answer that question for me?
I can tell you, I can tell you how that, I don't know if this board ever did that, I don't pass that.
It's allowed use on that property.
Well, surely the planning commission or somebody knew about the deal coming in there.
Marcus just said it was an allowed use on that property. Whatever the zoning was on that property, it was allowed. It could go there without being rezoned or anything.
And you have part of this land already C3 commercial. So what's the big deal about going on and making the rest of it C3? It's not gonna bother anybody. It's not gonna bother a soul. But I appreciate your time and I thank you for listening to me.
Thank you.
Thank you.
Anyone else? Anyone else? Anyone else? Ms. Cannon, you got your rebuttal?
So the first thing I would like to address is neighborhood. Oh, I'm sorry. My name is Lisa Clark Cannon. I reside at 13017 Forts Lake Road. The first thing I would like to address is the neighborhood. Mr. Calmer brought that up. And of course, a neighborhood definition can be very ambiguous. For some people, a neighborhood is a single road, a cul-de-sac, where 7 houses reside and they consider that their neighborhood. In our area is very large. Ms. Roberts cited that she is multi-generational owner. Well, I'm here to tell you I am also multi-generational owner, as is several of the other people that are sitting in this audience. So my great-grandfather, W.R. Clark, owned thousands of acres of land out there. That has been disseminated through his children to their children and so on and so forth. You've got Mr. Patterson. 2 of those individuals are sitting out here. They're 5th generation, I believe, and I may be off on that. Maybe they're 4th, but 4th or 5th generation. You also have Presleys who are out here in the audience, and I guarantee you they have been out there for many, many years as well. So when you talk about generational ownership in a neighborhood, to me, those thousands of acres from north of Forts Lake Road, all the way to the Alabama state line, coming all the way down to Franklin Creek, that is my neighborhood. For me to have to traverse through commercial areas is not something that I personally would desire doing. Now, they say that the traffic is an issue, and I agree, it is an issue. Most of that traffic is coming from Alabama, flowing into Pascagoula for work. But the neighborhood designation, in my humble opinion, is much larger than a single street with 7 homes on it or a cul-de-sac, or even a single street, Independence Road and Franklin Creek Road. Our neighborhood is vast. These people I have known personally my entire life, and many of them have known my parents and grandparents and so on and so forth. Our neighborhood is huge. Commercial businesses. What is the benefit? So commercial businesses exist within 12 miles from where I live. When I'm saying commercial businesses, I can come to Walmart, that's about 12 miles from my home. I can go to Publix over in Mobile, that's 12 miles from my home. I can run into Grand Bay, that's around 10 miles from my home. Now I'm talking major big box stores. Then you have smaller businesses. I can leave my home and go pick up a pizza over on Highway 63. It takes us about 7 minutes to get there. By the time we order, it's ready when we arrive. So we have fast food restaurants that are available on Highway 63. We have fast food restaurants that are available at Exit 4 in Grand Bay. Also a very short drive. When you live in a rural community, those drives are not like right here in Pascagoula where you run around the corner. Those drives are what we are accustomed to, what we enjoy, and what we want. There is also medical facilities at both of those exits. There are pharmacies at both exits. There are sit-down restaurants, fast food restaurants. There are truck stops at both exits. There are plenty of places for fuel. There are hotels at the exit 69, so if you've got a traveler that is looking, I guarantee you they've already looked on their Google map, and they say, oh, gee, we can stay at this exit or that exit. So all that is easily accessible by travelers as well as other people. So when you say neighborhood and you say, well, let's look at the interstate traffic. The interstate traffic has facilities that they can utilize, all within a very short distance of this particular exit. When you talk about the wetlands and the flooding, so yes, flood zones have changed drastically. Katrina, Frederick, all of those storms made us well aware of the flood zones. And thank you, I don't know that all of you served on the board, but Jackson County has done a great job in mitigating the flood area. And what we don't need are buildings that are going up and development that is going up in areas that are already flood prone, because we all know if you take a bowl of water and it's full, and you set another something inside that bowl of water, that water is going to be displaced and it's got to go somewhere. So maybe this property is not in a flood zone, but by developing it, in my opinion, it is going to impact the surrounding area that is flood prone. Access. He talked about, well, gee, there's not access to the already commercially zoned properties. So where the marijuana dispensary is, there is access there that is visible from the interstate, and the access is Old Stage Road. So you have Old Stage Road that is a 2-lane road and is accessible to that particular property. You have Highway 90. That property is zoned right here. So this little red strip, Highway 90, that's a 4-lane road, and it is zoned appropriately for development. I-10, yes, there's no access roads currently, but any developer that's going to go in is going to have to develop access roads for any property off of the interstate. Now, I don't think that's something that the state or the county should be held accountable to do. That should be a developer, just like a developer that's going to put in a subdivision. If they're going to do a subdivision, they need to do studies on drainage. They need to have roads and drainage issues all addressed. None of that is done. Now let's address the 4 or 5 miles away. So yes, I live about 4 miles north of I-10. This exit from Forts Lake Road to Independence Road to Franklin Creek Road, that is the only access that anyone in the neighborhoods of Franklin Creek and Forts Lake, Jackson Creek, that entire area, we have to traverse that in order to leave our neighborhood. So again, we are very concerned about the development and additional traffic. It's already a dangerous area. There are many, many accidents that happen in that particular area. In one day, about 3 weeks ago, there was an accident at I-10 coming off of the exit there at the Franklin Creek area. There was an accident there. There was another accident at Highway 90 and Franklin Creek Road, all same day. There was another one, but that one was in Alabama. We won't go there. 3 accidents within 5 miles of this location. One of them was catastrophic. It was a fatal injury. The annexation, that was brought up, I believe, by Mr. Cumbus. Don't hold these people hostage because of an annexation. In my opinion, this is a cause for Pascagoula to point out and say, oh, look, there's development and there is a reason for us to annex. I firmly believe that any type growth of this type nature would help the Pascagoula cause, and thank y'all for opposing that situation. Thank you. So by Mark's own admission, he's already working to find other buyers for more of Ms. Roberts' property. Ms. Roberts does not live in Jackson County. Now, she says she owns 600 or 800 acres. That's great and good, but she has no vested interest in living here, experiencing what commercial development does, the traffic and the other hazards that commercial development often brings in. She is removed from that. So what is she looking at? She's looking at the dollar signs. And I guarantee you the adjacent property owners who signed that petition are all, most of them, I believe, is vacant owners. So they don't live in the neighborhood. They're not neighbors. They're owners of property. When it comes down to more commercial, again, you've got plenty of area near I-10, on Highway 90, that is ready and developable. What this is about, in my opinion, is deep pockets. Would it help the county? Maybe. Depends on what goes in out there. You know, is that a sacrifice that you should make to hurt the neighborhood, to hurt your constituents, the people who vote you in or out of office? You know, you have to look at all of that. Again, you're talking about people who live there versus people who live outside and own property. Maybe the original intent was not to flip it. That's what she stated, Ms. Roberts. But again, it's about the dollar. Same thing with Mr. Cumbus. It's about the dollar. He's earning commissions on all of these contracts that he's writing. The other thing is they also said they would make a concession. They would say, well, let's take it from Highway C3 to Highway C2. That's still commercial. It still brings in an influx of all the things that we're opposing, we as the neighbors in the neighborhood. And that is not just the Franklin Creek Independence roads. That's the neighborhoods who have to come through this area in order to access where we work or where we worship, things like that. So it's still a huge impact. Trying to see if
Excuse me, Lisa. Mark, tell him he needs to not talk. The lady taking this down, she can't hear. She can hear two voices going on. Go ahead, Lisa.
Thank you. Do y'all have questions for me? Anything that you feel that I should address on impact, the neighborhood? Mr. Comer, did I address the neighborhood appropriately to say our neighborhood is not just a few streets, it is acreage?
I think that's not for me to say. I think that's for the board to determine what the neighborhood is in this particular situation. My goal was just to get as much discussion and as much facts out as I possibly can for the board's sake.
Okay. I do recall that a petition was mentioned about people in support of. I believe we submitted a petition that had over 100 signatures in opposition of. So I do want to state that as well, and I believe that it's already in the record.
It's 110.
110. Thank you, sir. How many were in favor?
There's about 42, 44, somewhere around there.
So I will point out that the 110 are people who live there, and I would just about bet you that the 40 or so are absentee owners.
33.
When you say live there, is this the immediate neighborhood or the 4 or 5 miles around?
The neighborhood, in my opinion, Mr. Taylor, encompasses that 4 or 5 miles. So when I think of my neighbors, I think of Billy Pattison, who's sitting back here in the very back. Mr. Pattison's probably in his 80s. We speak on the phone frequently. He is my neighbor, but I live about 4 miles from him, maybe 4.5 miles from him. I consider him my neighbor.
Okay. Jimmy brought up the neighborhood, and sitting here reflecting, I understand we've started talking about 2 neighborhoods, the traffic on I-10 and then the residential. And while I'm sitting here, I have come up with another neighborhood to throw into the mix. And that neighborhood, I'll call it the I-10 interchange business neighborhood. And we saw, not there, but we did see the status of every interchange in I-10 is commercialized, except the one we have in Goshen, which is Birdland. But to me, that should be recognized as a neighborhood also, because it is so comparable to each other.
And I would agree. You do have a commercialized area, and I would agree that would be a neighborhood as it sits, as it's designated today. So you have C3, you also have C2. And the C2 does have 4-lane access, unlike this property, which if you've driven out there, this little road, once you exit I-10 and you get off of that on-off area, it narrows down to a 2-lane road with no shoulders. There are ditches there, but there are no shoulders. It's a very narrow road, And it's a short road, so from I-10 to Franklin Creek Road, I'm guessing is a quarter of a mile, but it's all very narrow, no shoulders.
But this remains the only one that could be developed that is not developed in the state of Mississippi.
I'm
And
sorry?
I think that's significant.
Would you repeat that, sir? I'm sorry, I didn't hear you. Someone coughed.
This is the only interchange in the state of Mississippi that could be developed that is not developed.
True. Okay, so I'll agree. Again, there's plenty of zoning for that type development in the appropriate place versus going further into the neighborhood north of.
And now you're narrowing it down.
Well, I think it needs to be, in all due respect.
Okay.
Thank you, Ms.
Thank you. I appreciate it.
Marcus. Anything else we need, Marcus?
Yes, sir. And I think what Mr. Calmer's saying is, you know, there's not a definition for neighborhood. That's left up to the board to determine what the neighborhood is. And you need to hear from anyone else?
Now, I know the applicant gets a rebuttal. Lisa got the rebuttal. Do the rest of them get a rebuttal if they want it?
That's up to the
Oh,
board
is it
to
up to
determine.
us? Okay.
If you need to hear any more information, if you need to hear from,
To be honest, y'all, I've got enough information to make my decision, so
I think we need to move on.
yeah,
Thank you.
okay.
y'all good? You don't need to hear from anyone else? Any more questions?
Well, I've got a couple of more comments, if it's us now.
Yeah, any more? Any
Okay,
more?
I just commented about the neighborhood I'm throwing into the mix. Talk about public need. If people want to invest in property to make it into a business, then that, to me, demonstrates clearly public need, and I'll throw that out there. Another comment we've not even thought about yet, I think legal precedent, if this issue gets to the court system, ultimately, the Supreme Court is going to say it's going to become commercialized. And I do believe that because of, I'm not sure if there's case law there, but it appears there may well be. So I think that my recommendation is we support the Planning Commission recommendation, or vote, really.
Can I get a second?
One of the things, and I'll just say this, and Jimmy, you can correct me if I'm wrong, but it's really a two-pronged test, right?
It absolutely is, yes.
Yes, and so you have to prove that in order for a zone change to be done, you have to prove a change in character of the neighborhood, however you define the neighborhood, whether it's big or small or just around the interchange or whatever, you've got to prove that there has been a change, a substantial change, and then you also have to prove that there's a public need. So just a public need doesn't get it, or just a change doesn't get it. It has to be both conditions met.
Yeah, this may be more of an intellectual discussion, but I think that if there was no residential anywhere, if there was no church and no gas station and nothing but farmland all around there, and Buc-ee's wanted to come put a place off this interchange and wanted to get it rezoned, it may be difficult. If you look at just what the Supreme Court, the Court of Appeals have said, because Buc-ee's would have to show, again, assuming there's nothing around, they'd have to show a change in the character of the neighborhood. That's just what the courts have said. And so one of the reasons that I've kind of interjected myself more than I normally would is because I know if one party appeals this to circuit court, then there needs to be all of this considered and discussed. And that's why I've kind of thrown out more than once what the law says. Mr. Scruggs and Mr. Cummings made a presentation, Ms. Wright. Y'all have got to decide whether or not their presentation and what y'all know about the area, you can take that into consideration, meets that two-pronged criteria, a change in the character of the neighborhood and public need, both proven by clear and convincing evidence. And so that's kind of it in a nutshell. But it sounds crazy that if Buc-ee's want to come there and there's nothing else around and nothing had ever changed, a bunch of farmland, let's just say, and all you've got is that highway commercial right there where you have it, it may be tough. Now, not saying it can't be done, but I had this discussion with 2 other lawyers in the office. How does an intersection ever start to be developed? I'm just telling you what the case law says and what Marcus says, and I think that's the standard that has to be met, and it's up to you 5 to decide whether or not they have met that standard. And regardless of which way you go, either side could appeal it to circuit court. My office will have to defend it. But I just want to make sure that all this was out on the table, that it was thoroughly discussed. And again, I normally wouldn't interject myself into one of these that much, but I can see the issues, the kind of uniqueness of it, which is why I've talked more than normal.
Okay.
And it was much more thoroughly discussed here than it was discussed in the planning commission meeting too.
Thank you.
Just so you know.
Well, we didn't get a second.
Did you make a motion a while ago, or was that?
I did not.
Okay, that was just his opinion.
And,
Yeah.
and this area is another one of those areas on the cusp of, is it gonna start to grow? Or is it gonna kind of maintain that historical residential rural neighborhood that it's had? And we've got that all over the county where we're faced with, this is an area where we could go either way, really, because you could say, yeah, it makes sense and do it, but by doing that, you will truly change the character, and then all of a sudden, you're starting to lose the rural feel in those areas. So there's a heavy way on both sides on how to do this one, and this is right on that cusp.
Okay. Can I get a motion for the appeal?
Yeah. If y'all ready, I'm gonna go ahead and make a motion on this, and I'm gonna make a motion that we turn down the planning commission's decision on rezone 11-2025-00147 and deny this application on the rezone.
Can I get a second?
I'll second.
Got a second by Mr. Bozar. All in favor by say aye.
Aye.
All opposed?
Aye.
One opposed? Ayes has it. Thank you.
Okay. Thank y'all. Hey, Tom.
Thank you, sir.
Thank you. Thank you.
That's a big
Billy's brother, yeah.
Supervisor Morris, how you doing?
All right.
I'm Jimmy, yeah.
Attorney?
Yeah.
Thank you. Appreciate it. Thank you for your input.
Go back in executive session?
Yeah, we need a motion to go back into executive session.
He's a District 3 supervisor, Simon. Yeah. Thank you. You have a good day.
You too.
It's either he or his, he or his daddy used to work for the county. Really? I think it might have been his daddy. He's sitting back there. He was pretty old. He's Billy Patterson.
Wasn't back there, we standing here. In my name.
Yeah, he did.
Let me write that down, Mr. Taylor.
I really kind of.
We need a motion to return. Motion to return to executive session? Is that where we are?
All right, I'll make a motion to return to executive session.
Second by Mr. Ross. All in favor, by aye? Aye. Thank you. Motion passed.
How you been?
Executive session.
Good.
Yeah.